Hello and welcome to the Garrulous Gavel. I'm your host, John Tico, and today we'll be talking with Sara Kropf, one of the country's leading white-collar criminal defense attorneys, who will be explaining to us the mysteries of the grand jury. What is a grand jury? What does it do? What role does it play in our criminal justice system? We'll also be getting garrulous with Sara about why she left her cushy, big law firm job to start her own little firm, and whether the Washington Nationals will make the playoffs this year. Hope you enjoy it. Just wanted to let you know that we had a few small technical difficulties with the video portion of this episode, so you'll notice in a few spots the video disappears, but the audio is good. Stick with it. The video does come back. Thanks. Well, hi, I'm here with Sara Kropf. Thank you for coming down today.
Yeah, happy to be here.
It's sort of a warm, sticky Washington, D.C. summer day.
Very typical.
Yes. So we're going to be talking today about grand juries, the mysteries of the grand jury. And so let me introduce Sara to the audience a little bit so they understand who you are and where you're coming from. So the first thing to know about Sara is she spent a lot of time at Georgetown University, didn't you?
I did. 10 years total.
3 degrees, right?
Yep.
A bachelor's, a JD, which is a law degree.
Yep.
And then that wasn't good enough for you. You went and got a PhD as well.
I did a joint degree, so joint JD, PhD.
And despite the PhD, you decided to become a practicing lawyer.
Yeah, I got a little taste of academia and decided this was not for me. So.
Why is that?
If you think being at a big law firm is cutthroat, academia is like a whole other world. So I did not enjoy it when I was there. But a little known fact is my mentor was actually Bob Katzman, who became a judge on the Second Circuit and passed away recently. But he was the head of the JD PhD program. So he was amazing.
So the world of academia was too competitive and cutthroat for you, so you decided to become a criminal defense attorney.
Exactly.
It makes perfect sense. So after law school, you spent a year as a law clerk for a judge in the Fourth Circuit?
Yes. I was up in Baltimore.
And for folks who don't know what a law clerk is, what is a law clerk? So
a law clerk is usually someone who's just graduated from law school and you work for a judge. The judge I worked for was an appellate court judge, so we heard appeals. Well, I didn't hear appeals. The judge heard appeals, and we would help by doing some legal research, writing memos, helping draft opinions, and so forth. So it's a great job. That was also when I realized I didn't want to do any appellate work, that I really wanted to do trial work.
And what was it about appellate work that turned you off?
You spend a lot of your time in appellate work in an office, not talking to other people. So I like talking to witnesses. I like talking to other lawyers. I like talking to the people who are involved in the case. And in appellate work, you're mostly sitting in your office, doing legal research, thinking deeply, and doing a lot of writing.
Yeah.
It wasn't for me.
I had the same experience during my clerkship, so I totally know what you mean. So after you did your clerkship on the Fourth Circuit, you joined sort of one of the sort of cute small firms here in Washington, D.C., right?
Yeah, so I had been a law clerk at a small boutique firm called Miller Cassidy, LaRocca & Lewin, which was really an amazing firm. It had about 35 lawyers. One of the first firms in D.C. that did a lot of white-collar defense work. At that point, when they started, well before my time, the big firms didn't do white-collar work. It was seen as beneath them to do criminal work. But Miller Cassidy did that kind of work and was full of amazing lawyers. Right before I was ready to join them, and right before I joined them, they basically went over to Baker Botts, which is a Texas-based, very big law firm. So I was only a law clerk at Miller Cassidy, and then when I started full-time as a lawyer, it was with Baker Botts.
So this is a little bit of a detour, but why do you think the white-collar criminal defense practice wasn't attractive to big firms, but then became attractive to them?
You know, money is always the reason. I mean, I think in the beginning, representing individuals who were accused of crimes, I think was seen as a little unseemly, and the big white shoe firms didn't want to do it. That just, they viewed criminal work as all one kind of criminal work. And then I think they realized a few things. One was that these internal investigations, which really, going back to things like Enron and whatnot, kind of kicked off these huge internal investigations, which are technically criminal work. And those are incredibly lucrative because they're doing it for big companies. So I think the big firms realized there was a lot of money in it, and also the stigma of doing criminal work went away. And maybe they realized it was a lot of fun. That might be it too.
So it's not just because big companies started committing crimes that they hadn't been committing before.
No, I think anyone who knows U.S. history and the robber barons and all of it, that is a long-standing and tumultuous part of our history.
So you were at Baker Botts for about 11 years as an associate, and then eventually made partner.
Right.
And again, like you and I know what it means to make partner at a big law firm.
Yep.
But not everybody who's listening might know what that means. I'll let you take a crack at explaining it, and then if you get it wrong, I'll fill in the audience. Yeah.
So at a big law firm, you work very, very hard as an associate. Your job is basically to bill hours. It's not necessarily to bring in business, but you're just going to work as hard as you can. Depending on what firm you join, that can be upwards of, 10, 12 hours a day for most of the year. Baker Botts was not as bad as some of those huge firms, which traditionally the toughest ones are New York firms. But basically you work very hard for 6, 7, 8 years. That amount of time has certainly shifted, as you know, over time. It used to be that you'd make partner sort of automatically. If you'd stuck it out for 6 or 7 years at a firm, you'd make partner. I probably was on the tail end of the more automatic. If you could stick it out and you were still working there after 7 years, you'd make partner. So I was at the end of that. It's just gotten harder, I think, every year since then.
Yeah.
But there's a big decision point where they decide whether or not they're going to make you partner. Compensation goes up when you make partner, and then the pressure to bring in business goes up when you make partner.
Right.
Do you think is that consistent with your?
Yeah, I think that's basically right. I'm not so sure about if you just stick it out, you automatically make it. That was not true at the big firm that I was at, and that you were a summer associate at for a few weeks. But the rest of what I
didn't join.
Right. You didn't join. But that's basically right. But not to undersell yourself. I'll just say that you have a very, very impressive pedigree, and both the Fourth Circuit clerkship is a very competitive, prestigious position, and despite what you say, it's not easy becoming a partner at one of these large law firms, and the fact that you did is a credit, I'm sure in part to your work ethic, but also to your abilities as a lawyer. And I'll just say for the record that everybody who knows you thinks that you're very, very good.
Well, that's nice to hear. Say it often. Feel free.
So you were a partner at this big, giant international law firm, and we don't have to talk dollars, but I'm sure it's fair to say that you were being amply compensated for devoting your life to them and their clients. And then one day you wake up and you think to yourself, I should leave this cushy big firm and just hang out a shingle with my own name on it, right?
Yep, I did.
So so you left in 2013?
Yep.
And you started your own law firm? Yep. And was that literally just you, or were there people joining with you?
No, it was literally just me. I will say, I sort of made partner at Baker Botts and got a taste of what it was like to be a big firm partner. And look, I was not someone who hated my law firm. There's lots of, and you know them, there's lots of people who really don't like their firm. I genuinely liked pretty much everyone at the firm. I liked working there. We did complex work for interesting clients. And I actually really enjoyed it. I was not expecting to like it. I had a plan. My husband and I had a plan. He's a lawyer as well. We were both going to work, pay off my loans. He was going to stay at his law firm, and I was going to go be a public defender. It turned out he hated his law firm, and that will go unnamed where he was, and I really liked my firm. Yeah. And so it was interesting because he then went into the government, so we had a little bit of a swap. Yeah. But I made partner, did it for several years, had actually just made equity partner, which is kind of the next level of partnership, and just I wasn't enjoying the practice as much as I wanted to. And in large part, it was, I really like representing people. Individuals rather than companies. Mm-hmm. It turns out I really love representing small businesses and people. But at that point, at a big firm, to pay those kind of rates, which are, now, north of $1,000 an hour for partners.
Over 2,000 from what I've heard at certain
I have
firms.
heard that too. It has to be a big company. And not that it's not interesting to represent big companies, and some people love that work, but I did not enjoy it as much as I wanted to. And then the usual, office politics come up, but that was a much smaller reason. It was mostly that I wanted to represent individuals. And you're right, I was very well compensated. I had no complaints on that side, but I wasn't enjoying it, and life is too short. So I left Bigger Bots. I had no clients, not a one. I'm not sure why I didn't realize I could join a wonderful small firm first, although I think I probably chatted with you before I left or right after. I can't remember. But yeah, I just kind of dove in with both feet and started my own firm.
Yeah, no, that's fantastic. I remember when my partner Hassan Zavari and I left our big firm.
Yep.
We got very mixed reactions from the partners of that big firm when we told them what our plan was.
Yep.
Because at least at that time, it was a little bit unusual for people to leave. At least more junior people. It was somewhat unusual for more junior people to leave the big firm to hang their own shingle. I mean, people were leaving all the time, right? Every Friday happy hour, we were wishing somebody well, but they were typically either doing the revolving door thing with DOJ or one of the government agencies, or they were going in-house at a client of the firm. But for a junior person to go start their own firm was unusual. And I recall that some of the partners were just sort of bamboozled, didn't understand it at all, thought we were crazy. But there were a few who were like, I wish I had done that when I was your age.
And I remember when you all did that. Yeah. And I remember thinking you were a little crazy. Because I was like, wow, here you guys are. You guys were like senior associates.
Yeah, we were. Right.
And I don't think I knew anyone personally who had done it. I remember watching you guys do it and not thinking, oh, that's something I want to do, because I was a couple years behind you, but being sort of intrigued by it. Right. And I had the same experience when I left, which was, one of the partners I told looked at me and he goes, have you really thought this through? And my heart just sunk at that moment. It was, so there was definitely, and it wasn't so much doubting me, but to your point, doubting why would you ever do this?
Right.
And then same thing, like after I left, you could almost predict someone would email you who you hadn't talked to in a while, who's at a big firm, and you're nodding your head saying, hey, can we grab lunch? And you'd have lunch with them and they'd be like, how is it? Yeah. I want to leave. I've been thinking about leaving for years, and sort of hearing how many people have had this dream, and most of them don't do it. You've done it and I've done it, and it's the best thing I've done in my career. It probably is for you too. But
well, good.
Lots of doubting Thomases.
Okay, so we're going to come back to this topic because I think this is this sort of question of big firms versus little firms and what it takes to start your own practice. I think it's just an interesting human interest story.
Yep.
And maybe an instructive story to other lawyers or people who are thinking of becoming lawyers at some point in their life. So we should definitely come back to it. But tell me a little bit about what the focus of your current practice is.
Sure. So we represent people, we defend people. So we defend people and small businesses who are under federal criminal investigation. It's pretty much all federal work. So government investigations, traditionally from Department of Justice, but oftentimes from agencies, offices of Inspector General. Each agency has someone who can investigate you. We do a lot of OIG investigations, and a lot of the work ends up being for certain regulated industries. Government contractors get themselves in a fair amount of trouble. As you know, you're sort of on the other side of some of it. So we do some False Claims Act defense work. But mostly it's representing individuals and small businesses who are sort of in crisis and under investigation.
So now you're saying we.
Yes.
So when you started in 2013, it was literally me.
Yes.
It was me, Sara Kropf. Yep. I will represent you.
Right.
So tell me a little bit about the we. Like, what has been the
change? Yes. So in September 2019, Andrea Mosley joined me. Andrea and I have known each other for several years. She's a former public defender in Virginia, and then had her own firm, and then worked at a boutique firm in Alexandria. True defense lawyer. I mean, anyone who's been a public defender has sort of been through the ringer in the way that my practice is like a big firm lawyer is sort of soft.
Yeah.
And so we both do white collar criminal defense work, and then we both do civil litigation as well. So Andrea joined, September 2019. We were getting into a good rhythm. And then all of a sudden, the pandemic hit, so we're getting back into being in the office.
Little thing
together.
called COVID.
Yeah, exactly.
Exactly. And do you have other folks working for you now?
So we have an assistant, a virtual admin who helps, and then we are literally in the process of hiring an associate. We had an associate before. He left per your revolving door comment. He went to DOJ. Yeah. And now we're in the process of hiring someone.
Okay.
Yeah.
Excellent. And you are also a prolific blogger.
I am. I don't know if I'd say prolific, but I am a blogger. Yes.
Well, it's okay. It's maybe not prolific, but what you write is very good.
Thank you.
And you write substantive, interesting stuff that I like to read. And so your blog on the web, although I assume people can find you in other places, but grandjurytarget.com is your blog website. And that kind of leads us into, I think, what is going to be our sort of substantive topic for today, which is talking about the grand jury. So why is your blog called Grand Jury Target? So
I know we'll talk a little bit about grand juries, but a grand jury target is usually a person, but can be a company who is the target of the grand jury's investigation. So they're the person who's in the crosshairs, likely to be indicted. And so it's funny, I was casting about for what to name my blog. And I was at lunch with someone who's a partner at a big firm. And I was like, I can't figure out what to name it. And he's like, Grand Jury Target. Oh, it's so obvious.
Who's your client base?
Yeah, exactly. That's exactly what he said. He's like, well, what do you want to do? I was like, Grand Jury Investigations. He's like, Grand Jury Target.
Yeah.
So that's why it's named that. And that's why, Grand Jury Targets, it's an unfortunate thing as a criminal defense lawyer that, of course, I want the best for my clients. But the most interesting work are the people who are the targets. I mean, the most interesting work that I do are people who have been indicted or will be indicted.
Yeah.
Yeah.
I think that is true of a lot of lawyering, particularly if you're a litigator, which is that in some sense, the cases that are the most interesting and the clients that are the most interesting, they involve like the biggest problems.
Right.
And so for the people we represent, they're not in a good situation often.
No, and yours are often, I know, like the victims, and they're the people who something bad has happened to.
Right. They've come to us with a problem.
Exactly. And mine are people on the other side or are accused of doing the bad thing.
Right.
And they are in crisis. I mean, I think half of my job, and one reason it turns out I love it, is the hand-holding part of it.
Yeah.
I mean, half of it is legal, and that's what we do. And part of it is getting people through a crisis and being there for them. Yeah. Yeah.
But it is this weird psychological thing that I think took me a while to get used to as a lawyer of, maybe doctors go through this too. It's sort of that people come to you when they're in crisis. But for you, that moment can often be like a very satisfying professional moment. Like, oh, I got this new case that seems it's a big, interesting, juicy case. And you think of it from that perspective, right? Well, obviously the client is just like, gee, I hope this crazy person can help me because, I
mean, it's completely true. I mean, it's the more complicated the matter, the more trouble you're in, the more I'd love for you to hire me.
Right.
And it's their worst moment. And I wouldn't say it's my best moment, but it's the people who are they're in crisis.
Yeah. I think it's one of the many sort of interesting psychological conundrums of being a lawyer.
Yeah.
All right. Well, let's talk a little bit about grand juries. Okay. This is your area of expertise and why I wanted to bring you in here to talk today. So grand juries have been in the news a lot lately. I mean, I guess they always are.
Yep.
You hear that so-and-so was under investigation by a grand jury, so-and-so got indicted by a grand jury. We're sitting here in the second week of July of 2021, and we're about a week removed from the announcement that the Trump companies and Trump's CFO, Allan Weiselberg, were charged by a grand jury sitting in New York.
Right.
And there's been some other interesting grand jury related cases over the last year or so that we can talk about.
Yep.
But let me just to sort of introduce this topic. Let me kind of set up the situation with the Trump grand jury and the Trump indictment. So on July 1 of this year, 2021, a grand jury sitting in New York, overseen by a New York state court.
Yep.
Correct?
Yep.
Issued an indictment, and we can talk a little bit about what that means, but they issued an indictment accusing the Trump Corporation and I think a subsidiary of the Trump Corporation and this individual, Allan Weiselberg, who is the CFO for Trump, of various crimes, mostly involving various forms of tax evasion. Okay. And if you read the actual indictment, which I have.
You're ahead of me. I haven't read it.
Okay, it's an interesting story.
Yep.
But you probably know
I've read the news story.
You've read the news story,
yep.
And given who you are and what you do, you could probably just write the indictment,
yep.
And you would be pretty close to what it actually says.
Yep.
But the indictment starts out with the following words. It says, quote, "The grand jury of the county of New York, by this indictment, accuses the Trump Corporation, Trump Payroll Corporation, and Allan Weiselberg of the crime of blank." Mm-hmm. And then there's a series of counts where they're accused of these various crimes. So if you just read that document, it sounds like this entity, this grand jury, whoever that is, right, is the one making the accusation against the company and against the individual of the crimes. And then I went back and looked at some of the news reportage around that event to see how it was sort of characterized by various reporters. And what I found is that there was two sort of approaches that the reporters took in reporting that indictment. So I'll just give you some examples. This is just to sort of set this up. So the Washington Post on January 30th, they have an article about this. It's the night before the indictment was publicly released, but they had already seen it or already heard about it. So this is how the Washington Post reports it. They say, quote, "A grand jury in Manhattan filed criminal indictments Wednesday against former President Donald Trump's company and his longtime chief financial officer." Okay. So they're describing this event as a grand jury filing indictments. All right. Here's the New York Times. The next morning, their article starts, and I quote, "The Manhattan District Attorney's Office, which has been conducting the investigation alongside the New York Attorney General, has accused a top executive, Allan Weiselberg, of avoiding taxes," and so on and so forth. Yep. So that journalist describes the event as the District Attorney's Office accusing the defendants of the crime. And then I pulled one more. This is from pbs.org. I don't know if anybody ever looks at pbs.org.
I don't think I ever have.
Yeah, I did, but I do. But PBS is sort of a reputable organization, sure. Right? So they described it as, quote, "Officials in New York have indicted the Trump Organization for an alleged blah, blah, blah."
Sure.
So there seems to be sort of two different ways that these events are described in the press. Sometimes the event is attributed to the grand jury, and sometimes they just skip past the grand jury and they say this is a prosecutor who is accusing this person of a crime. So which one is right?
In a way, they both are, I guess. It's definitely the prosecutor who's the driver. So the prosecutor is going to the grand jury and asking them to indict.
Okay. So tell us what a grand jury is. All right, so, I think we need to define our terms.
Yeah, so right? what is a grand jury? Because if you haven't been called for grand jury duty, then you would have no idea what it is. So a grand jury, in a way, is similar to a regular jury. So it has a different size. And I really only know the federal system, so I don't know as much about the New York state system. But it's in the federal system, it's 16 to 23 grand jurors. Yeah, they're regular people. So they're people probably not like me. I would not probably get put on a grand jury because I'm.
But they're pulled. Are they? They're pulled from the same pool as the trial juries.
Yep. Yeah. Exactly. Their term of service is very different. So for example, I live in the District of Columbia. If you get called for jury duty, it's called one day or one trial. I think it's pretty much the same everywhere. If you go in, if you get picked that day, you sit for that trial, and that's it. Or if you don't get picked, you go home. Mm-hmm. Grand jurors get called for a much longer period of time, which can be something, it can go up to, I think, 18 months if it's not renewed. However, they usually don't meet every day. So sometimes they'll meet once a week, sometimes they'll meet twice a week, sometimes it's shorter, longer. You can imagine who ultimately has time to do that, which is oftentimes retired people. Mm-hmm. I mean, it's a real challenge for someone who works and has a job where they need to be there to take, obviously you can't take 18 months off, but even 1 to 2 days a week for a lot of professionals would be difficult. But the grand jury sits and they hear, unlike a regular jury, they hear multiple cases. So the prosecutor, whoever it is coming in and presenting multiple cases. So witnesses for the cases, showing exhibits, and presenting the law that they're going to apply. So they present the evidence for a certain case and they ask the jury to indict, let's say indict a person for specific charges. And then the jury gets to decide, the grand jury gets to decide. I don't think it has to be unanimous. I think it's just a majority even. To whether or not they're going to, we call it, technically it's called returning a true bill, mm-hmm. but it means indicting the person, which mm-hmm. means the formal charges are filed.
And does the potential defendant, do they have any say or any opportunity to present evidence to the grand jury?
No. So grand juries, they're really fascinating. I mean, it's a fascinating process. It's supposed to be to protect defendants. It's supposed to be a little bit of a hoop that the government has to jump through before they can indict you for felonies. Misdemeanors generally don't need them. And so it's supposed to be there to protect the defendant. It's supposed to be there to protect from, an individual prosecutor just going out and charging someone for mm-hmm. something that has no basis whatsoever. Mm-hmm. But the issue is the standard there is very low. It's generally probable cause. So it's, is there probable cause that there's enough evidence here that a crime was committed? And the defendant is not present. So the actual proceedings are in generally a conference room. The defendant is not there. The defense lawyers are not there. The only people who are in there are the prosecutor or prosecutors, the actual grand jurors, the court reporter, and then whoever is testifying. So the defendant technically has a right to testify before the grand jury. If you are the target and you want to testify before the grand jury,
yeah.
If you prefer to commit suicide, you may go testify before the grand jury.
How would you know you're a target?
You get a target letter. So you will find out. It's a rare circumstance where you don't know, at least in the kind of work I do, white mm-hmm. collar work, which is like fraud, conspiracy. Mm-hmm. You get a written letter ahead of time that says you are the target of a grand jury investigation, and here's what we're thinking about charging you with. If you'd like to get a lawyer, you can do so. Is
that standard practice in the federal system?
It is. Yeah. There's a U.S. Attorney's Manual that I don't think requires a target letter, but is very standard practice.
Do they do that even in like drug conspiracy cases, or is that? I mean, that would make sense to me in corporate fraud cases,
right,
where the corporation is going to lawyer up anyhow, and they've probably figured it out because they've heard about the witnesses being called.
Sure.
There's no real secret there, right? So if anything, they're kind of being like, all right, if you want to come tell us something, now's your chance, right? But like in a drug case or a violent crime case, do they send a letter to the head of the drug gang saying no? I mean, probably not.
I don't represent really drug gangs, but no. I mean, so if you're arrested, for example, like if you're caught doing something, selling drugs, committing a violent crime, I mean, it's you are arrested, the crime has been committed,
right,
and the grand jury will be convened, and they're not going to give you a target letter. You've been arrested and probably are being held. So it's not like there's any mystery there.
Yeah.
So I don't think so, but I mean, honestly, maybe they do. I don't.
Yeah.
I haven't. They did. That never happened on The Wire. So
That's how we all learn.
Exactly.
Yeah, everything you know about a grand jury, you've learned from The Wire.
Exactly.
Or some other
that's,
TV show. Because as you told me, you've never actually been inside the grand jury.
Exactly.
Room,
yeah.
right?
I
These
mean,
are
it's
just controlled by the prosecutors.
They're entirely controlled by the prosecutor.
I remember from and I don't practice criminal law, so I've never dealt with this, but I took criminal procedure when I was in law school a few years back, almost 30 years ago now.
Yeah.
And I remember hearing this phrase, which I then went back to look up to see if I had recalled it correctly. And you probably know what I'm going to say because every lawyer has heard
There's
this,
a sandwich, right?
That a prosecutor can get a grand jury to indict a ham sandwich.
Mm-hmm.
That's the expression that probably every law student hears in their criminal procedure or criminal procedure class. And I looked it up to see if that was right, if I had remembered it correctly and like where that comes from. And apparently there's some dispute about who actually
where does
came
it come
up
from?
Well, I mean, all I could tell from the internet, right? So take it with a grain of salt.
Yep.
There was a judge in New York named Saul Wattler, who I remember him. He was the chief judge of the Court of Appeals in New York, which is the highest.
Yep.
And he claimed credit for having said that phrase, and it was attributed to him. But there's some dispute. Apparently, somebody looked and had found similar attributions of sandwich indictments that predated when Judge Wattler claimed to have said it first. But in any event, I guess it came into common parlance with Judge Wattler back in the 1980s. That's the genesis of that. But the point of the cute saying is that a prosecutor who wants to charge somebody with a crime can get a grand jury to do that.
Yes.
And if they can't, they're incompetent. I mean, that was kind of what he was saying. Like, you could indict a ham sandwich.
I mean, it's a one-sided. Yeah, it's a complete. I mean, imagine the circumstance. The grand jurors who know nothing about the case and nothing about the law are sitting, and they hear. Oftentimes, these cases are brought simply by putting a case agent on the stand, so an FBI agent. So there's no judge in the room either. So the rules of evidence don't matter. It can be hearsay, so it can be secondhand information. And the jurors who are sitting there hear evidence presented only by the prosecutor in favor of indictment. They are not required to put on...
Usually. We'll come back.
We'll come back. All right. And good way to build a story. I like that. And so they're only hearing one side. They're only seeing the evidence that supports the idea they should return an indictment. And then they hear argument from the prosecutor and no response from the defendant. So you can imagine how easy it is to get an indictment.
And what role are the grand jurors themselves playing in that process? In other words, are they just sitting passively and watching, or are they allowed to ask questions? If there's evidence they want to see, can they go out and get that evidence and sort of, rely on that? Or, how active or passive are the grand jurors in that process?
They're fairly passive.
Yeah.
The only firsthand knowledge I have is from reading grand jury transcripts, which if you end up going to trial, you get the transcripts. They are allowed to ask questions. They can ask questions of the witness. They can ask questions of the prosecutor. I have seen circumstances where the prosecutor essentially tells the grand jurors to stop asking questions. But certainly they are allowed to do that. They're allowed to ask the prosecutor to bring in witnesses. The prosecutor can completely ignore that request. They certainly don't have to abide by it. Grand jurors cannot go independently and ask for evidence. They can't go outside of the grand jury process. They can't do their own investigation or anything. They can ask the prosecutor to subpoena certain documents or bring in a witness, but, for the most part, they're completely passive. I mean, I have read transcripts of grand jury testimony that are 250 pages long, and it's the prosecutor asking questions and the witness answering. There is not a single question from the grand juror, any grand juror. So they're reasonably passive.
Yeah. And now when you sort of compare that to the asserted justification for having grand jurors, which is that they are supposed to act as this sort of buffer against prosecutorial overreach, or that they are supposed to, well, I don't know if this is the justification or not, but that they are supposed to somehow represent the conscience of the community in deciding who to accuse of crimes. It doesn't seem like they really are playing that role very often. Although one of the things I looked at before talking to you is I was trying to educate myself about grand jurors. There is something called the Handbook for Federal Grand Jurors, which I take it is a document that the grand jurors are actually given by the courts.
If they become a grand juror. To explain the grand jury process to them. I wonder how do they describe it as indicting a ham sandwich or not?
No, that's the interesting thing. So it starts out, the purpose of the handbook. I'm reading from this document is called the Handbook for Federal Grand Jurors. You can find it online. It says, this handbook will acquaint persons who have been selected to serve on a federal grand jury with the general nature and importance of their role as grand jurors. And it goes on to talk about the history. And they start out by giving the history of grand juries. And at least according to this document, they say that the grand juries were recognized in the Magna Carta back in 1215, and that they originated in English law. And they really describe it as a check against the prosecutorial authority of the English crown. Mostly by other English noblemen, right? Which was really what the Magna Carta was about, right? They really weren't worried about me and you. Yep. They were worried about protecting their own little smaller castles from the really big castle on the hill, I think. But in any event, that's how it's described, and that's how it's described to people that are going in to serve as grand juries in an American grand jury. So they're sort of told, like, you grand juror are the descendants of the Magna Carta, and you are this check on governmental overreach. But I take it that almost never happens, or maybe actually never happens. I don't know if there are statistics about. There aren't.
And I mean, I think there would be fascinating to see it. And of course, DOJ, Department of Justice, does not put out statistics, but I would guess, if you think about people who are criminally indicted in the federal system, 95% of them plead guilty.
Yeah.
95% of them. So only 5 end up either 5 go to trial or they have the charges dismissed. And of those additional 5%, 30% or something are not found not guilty and 70% are found guilty. But at least we have those statistics.
But that sort of suggests that once the indictment is the important thing. Like once you've been indicted, you don't stand much of a chance. Things are stacked against you for a bunch of reasons.
They are stacked against.
That's a whole nother story.
Yes, that would be like a 7-hour podcast that your probably listeners, maybe they won't listen to.
We'll have you back for that. Exactly. There's some interesting stories there too, I think.
But you're right. I mean, the indictment is the important part, and it's very, very easy to get. I mean, the prosecutor has complete control of that room.
Right.
The fact that the other side doesn't get to argue against it is the troubling part. And I appreciate that grand jurors have kind of a noble cause, but I think in practice it just doesn't play out that they get to really play that role.
Yeah. So we inherited grand juries from England. Mm-hmm. And as I understand it, in 1933, England abolished grand juries.
You're telling me that. I actually don't know that, but I find that fascinating.
This is another internet fact, but it showed up in more than one place on the internet, so I suspect that it's true.
Yep.
But regardless of whether 1933 is the real year or not, it does appear that most of the countries that inherited grand juries were former English colonies. Mm-hmm. Or commonwealths that sort of adopted the grand jury from the English system. Yep. And that, for the most part, the U.S. is the only major country that is still using grand juries. That they've gotten rid of them in other countries, as I understand it, because they realized that they were sort of silly and useless. Yeah. In the modern system. Right. Where we're no longer. Maybe the original justifications for it no longer apply, although maybe they do. That's an interesting question. We can come back to that. But, from where you sit and given your experience sort of representing the targets of grand juries, what is your take on whether or not they serve an actual useful purpose in our system today? I
don't think they're much of an independent check, but they're something. right? They are at least a level that the prosecutor has to get past. So I'm not sure if they do more harm than good, but I do think they are a little bit of a check.
What is the harm?
To not having them or to having them?
No, to having them.
I mean, there's a huge cost to the defendant as they go through that process, as opposed to just being indicted. So I think there's a benefit in that the existence of grand juries and the transcripts that are created certainly help on the defense side. I mean, at least somebody has had to testify, and if the witnesses at trial have testified in front of the grand jury, you get their testimony. And so it at least gives you some prior testimony to turn to.
So it's sort of become an indirect discovery tool for the defense.
I mean, we don't get much discovery. Right. It's not like a civil case, so we don't get depositions. It's kind of amazing that you put people in jail and don't let them question witnesses. You get many fewer rights. But it although I don't think it offers much protection from prosecutorial overreach, it just doesn't. It is at least a tiny little bit of a check. And then once you get past it, there's a chance to look at what the grand jury did, maybe challenge what the grand jury did, because if you can challenge the indictment, which is extremely difficult, but it at least is something to argue about as a defense lawyer.
If you could trade grand juries for the right to take pretrial depositions, would you take that deal? 100
times over. Yeah. I mean, if I could depose the government's witnesses generally won't even speak to defense counsel. They are not under any obligation to speak with us. You can't subpoena them the way you can in a civil case. And oftentimes the prosecutors have interviewed them. And while it's unethical for a prosecutor to say to a witness that they cannot speak to defense counsel, they oftentimes will say, well, the defense lawyers may call you. You certainly have no obligation to speak with them. If they're witnesses who are cooperating in any way with the government, they're not going to talk to defense lawyers. So being a trial lawyer in criminal law means getting up and cross-examining witnesses who you haven't deposed, and you kind of have no idea what they're going to say. Right. So being a trial lawyer, and I do civil trial work too, is much easier. I know what the person is going to say. Criminal work, you get up and do the best you can with the document. You do have documents, but it's a whole different type of trial lawyering.
And so does this system make sense? So I mean, let's start from the proposition that the goal of the system should be to put guilty people in jail and let innocent people go free.
Right.
I mean, I think we can agree on that, probably.
Yes.
Whether we could get everybody in the system to agree on that, maybe not. But I think most people, at least if they would ask that question out loud, they would have to agree that that is the ultimate goal of the system. And so, from what you're telling me, it sounds like there's a high risk of mistake at the indictment stage because the prosecutors have complete control over that. They can present a one-sided evidence. There's no cross-examination of witnesses. The defendant doesn't get to present their own evidence at that stage. And so there's at least a risk of mistake at the indictment stage.
Yep.
And from what you're telling me, once the indictment is handed down, your chances of actually being acquitted are exceedingly low.
Correct.
There's all sorts of institutional pressures that come to bear on people that cause them to plea when they may not actually be guilty of all the charges.
Yep.
And then it's very hard to win at trial because the trial, you don't really have good discovery. You don't really know what the prosecution's going to do.
Right.
It's just a whole bunch of reasons why it's hard to win those cases,
It
right?
is very hard to win. Yes.
So when you put all that together, it sounds to me like we are as a system tolerating a fairly high risk of mistake.
An incredibly high risk of mistake. And funny, I haven't read his book yet, but Judge Rakoff, who's a district court judge in New York, wrote a book called Why the Innocent Plead Guilty and Why the Guilty Go Free. And I heard him interviewed on another podcast, and it was fascinating. And some of it is about, why do innocent people actually plead guilty?
Yeah.
And part of it is all the pressures that you're talking about.
Yeah.
Because there is an unbelievable amount of pressure that's brought to bear, and a real limitations to be able to defend yourself. And so the cases that I handle it's not a drug case or a murder case or something where an incident happened. It's clearly illegal, right? Somebody was shot and that's homicide and somebody did something wrong. There's no doubt about it. The things that I do are oftentimes in a gray area. Somebody made a certain accounting decision. Well, was that accounting fraud or did they just mess up really complex rules? Did they have the intent to commit a crime? Mm-hmm. Intent is usually the thing we're arguing about. So sometimes there's even a question about whether or not what they did is even a crime. And prosecutors push the envelope. And so your point about mistake in front of the grand jury, they can go to the grand jury with a theory of something being a crime that has never been prosecuted in any other court in the United States. And they have control over the grand jury to say, we believe this is a crime, and here's the law, and you should apply it and find that and indict this person. And the grand jury doesn't know any better. They're not expected to know any better. The prosecutor knows they don't know any better. And so people get indicted for things that it's questionable whether or not they're crimes. Even if you believe all the facts of what they did what the prosecutor said, it's not even clear that this actually violates the law. So there's a huge problem on that side. And then when you are indicted, the discovery rules are so stacked against a defendant. I mean, it's staggering. I cannot subpoena documents freely. Right. So there are subpoenas that I can issue as a defendant, but in most courts I have to get the court's permission first. And if it's at all a fishing expedition, or I can't really clearly articulate what is going to be found, it will be denied. So I can't depose people, and I can't freely obtain evidence that I think will support my client. And you put people in jail because of it. I mean, you don't allow that in the civil system, right? You would never allow a case to go to trial without depositions of key people. I don't get to even take a deposition of the other side's expert. So the other side may have an expert witness, and I don't get to depose them. There might be a pretrial hearing on, Daubert and trying to figure out whether or not it should be admitted. I might get a preview then, but it's a really unequal playing field.
So if you go back and accept my initial premise, which is that everybody involved in the system should want the results to be correct, maybe taking off your lawyer hat for a second and putting on your doctorate hat, right? Because this is really like a historical political question. Like how did we get here, and why do we tolerate it? Why do we have a system like this where we convene grand juries that indict ham sandwiches? Why it seems like that not only does that, I'm sure, cost a lot of money to administer, but if it's just leading to bad results, why do we continue? How did we get here, and why are we still here?
That's a big question.
Yeah, I'm asking a big question. That's why I'm saying take off your lawyer hat. Lawyers don't think about big questions. We just think about winning the next case. Yeah. But lurking in the background, I think, are some of these sort of like bigger structural questions, and I think lawyers sometimes are not good at thinking about those big structural questions, and we kind of let them just go past us a little bit.
Yeah, and I think we take for granted how the system works.
Yeah.
Right? I do think people, as a general matter, until they're the one who are in a criminal investigation, are very comfortable with the idea of, well, if you're accused of a crime, you must have done it. There must be some reason there. And I feel like people are fairly comfortable with kind of quick findings of guilt. Because until you're the one who's in the hot seat, people don't, I think a lot of my clients who haven't been in the criminal justice system, which is pretty much all of them, they had great faith in the justice system until they were the one who was in the crosshairs. And so I do think for most people, it feels very distant to them. And that's just the process. That's how it works. We're okay with it. And most people who get indicted, it's probably because they did something wrong. I mean, I don't think anyone has any numbers to say most of the people who plead guilty are actually innocent.
Right.
So, and a lot of crimes are quite obvious, and that's why people plead guilty to them, and the evidence is overwhelming. But I agree. I mean, I do think there's a lot of acceptance of the criminal justice system that is disturbing. Given the numbers everyone has seen about people who are exonerated, who are literally on death row. I mean, I don't know how anyone can look at those numbers and think, yeah, our system is working. It's not working. And my clients are lucky enough to hire a lawyer. People who can't hire very good lawyers. I mean, take the system I just described with an uneven playing field and triple the inequality of it.
Right.
I mean, it's insane for people who can't afford counsel.
And so we've been sort of talking about the problem as being one of indicting people or ultimately convicting people who do not deserve to be indicted and convicted.
Yep.
But there are instances where the problem cuts the other way as well. And, so one that was in the news fairly recently is the Breonna Taylor case in Kentucky. And so this was the Black woman who was shot to death by a group of 3 police officers who were executing a search warrant in an apartment where she happened to be. She was not the target of the search warrant.
Right.
From what I understand, it was what they call a no-knock search. The police just sort of barged into the apartment in the middle of the night.
Yep.
And the gentleman whose apartment it was happened to have a gun, and he thought that there were intruders coming into the apartment. He fires a warning shot, according to him, one warning shot, and the 3 police officers empty some extraordinary number of bullets, seemingly at random.
Yeah.
I don't think I'm overcharacterizing the case. And Breonna Taylor, who was in the apartment, was hit by a number of the bullets and killed.
Yep.
And there was a great public uproar about that. And a grand jury was convened by the Kentucky Attorney General and to investigate the conduct of these 3 police officers. And at the end of that grand jury process, 2 of the officers were not charged at all. And the 3rd officer was charged with, I think, what they called reckless endangerment, not for killing Breonna Taylor,
right,
but for having just shot randomly and endangering people in the next door apartment.
Yeah.
So essentially, none of the 3 were charged with any crimes relating to her death. Right. And there was a lot of public attention to this case, and the Attorney General was under a lot of public scrutiny as a result of that. And he made a number of public statements where he essentially tried to pin the decision to not charge the officers in Ms. Taylor's death on the grand jury, saying, well, this was the decision of the grand jury. I'm just the Attorney General. I had no control over this. It was just and that then caused a relatively unusual and extraordinary response from a number of the grand jurors.
Yes.
Who, one of whom petitioned the court to be allowed to speak about what occurred. So before we get into that, maybe we should talk a little bit about why that grand juror had to ask the court for permission. Right, the Attorney General just held a press conference and said whatever he wanted about what happened, but the grand juror had to go to the judge and say, "Is it okay if I give my side of the story of what happened in the grand jury room?" So maybe you can say a little bit about the rules that govern grand jury secrecy.
Yeah, they are pretty extreme. So grand juries are secret. In the federal system, there are rules. I'm sure there are in every state system where the prosecutor, the grand jurors, the court reporter are not allowed to ever disclose what happens in the grand jury. And there's a good reason for that, which is for the people who, are who don't meet the level of a ham sandwich, people who don't get indicted. You don't want the grand jurors going and blabbing to people, oh, I heard so-and-so was under investigation.
Mm-hmm.
Like, for example, with the Trump case, let's say they decided not to charge him. Right. We can talk about our, views of that, but you don't want for people who, haven't even been indicted to have people talking about the fact that they were under investigation. It does a lot of reputational harm. So, and also there are some investigations that need to be protected, right? I think there have been cases. Sure. I think there was one famous case where a grand jury was investigating some mafia violence, and it turned out that one of the low-level mafia members was on the grand jury. And started telling the targets, you're under investigation. You better, do X, Y, and Z to protect yourself. And I think that person was also then like taking kickbacks in order to disclose it, right? And so there are dangers. So the witnesses who testify are allowed to talk about what happens while they're in there. But grand jury secrecy exists. It's taken very seriously by people who are involved in this. So there are leaks, but they're rare and definitely not favored even by the most aggressive prosecutors that I've come in contact with. Take grand jury secrecy very but at the end of the grand jury process, obviously the prosecutors do make public statements about what has, at least the end result of the grand jury investigations, and maybe in the Breonna Taylor case, the Kentucky AG kind of took things a little too far and was not only describing the indictment, but was making assertions about the grand jury's own deliberations that led to the indictment. Would that normally be considered a violation of secrecy, or are the prosecutors allowed to do that? No, I mean, they aren't allowed to talk about the deliberations or, what the vote was, and they usually are not. I've never heard a prosecutor disclose, we presented X. It's unusual. Let me put it this way: it's unusual for a prosecutor to disclose we presented X charges and they only indicted on these 4 charges and not these other 2. Right. I mean, they certainly could talk about the end point, which is, and that's usually what they do. I mean, U.S. attorneys have press conferences all the time to announce a big indictment, and they'll go through the allegations. But it's fine to go through the allegations; they're in the public document. It's not fine to talk about deliberations of the grand jury. And I think in the Taylor case, the Kentucky AG was trying to tread a thin line by sort of implying that the grand jury had considered and rejected more serious charges, murder charges against the police officers, maybe without actually coming out and saying those exact words. Right. But the end result of that story is very interesting. So the one of the grand jurors petitions the court that was the judge that was overseeing that grand jury. Yep. And in what I take it was a fairly unusual move, the judge issued an opinion basically releasing the grand jurors from secrecy and saying it's okay in this particular case for you to talk publicly about your own experiences inside the grand jury room and your deliberations. And this is an opinion by Judge Annie O'Connell, who was the judge overseeing the case, which she issued back in October of 2020. And in her opinion, she focuses very much on the fact that the prosecutor had made these public statements that seemed to be almost blaming the grand jury for the fact that the officers hadn't been charged. Right. And the grand jurors saying, well, wait a second, we were never told that we had that option. Right. Inside the grand jury room, so it's not our fault. I mean, that is that is highly unusual. I don't think the federal rule even permits a grand juror to ask for what they were able to ask for here. Yeah. And I've never seen that happen. So I think it's extremely rare and pretty fascinating. And I'd agree. I think it was that the prosecutor clearly was looking for political cover. He was getting pressure to indict from some people. And, there clearly has been resistance to indicting police officers for crimes that they commit in the course of being a police officer. I think most people can understand that that's a difficult job. It's a stressful job. They're making split-second decisions. So there's been a real reluctance to charge them. This certainly was an extreme example of conduct. Yeah. So, it was understandable he was getting this pressure. But it seems pretty clear that the prosecutor went to the grand jury, presented, it's hard to know, but likely a very weak case, didn't present the more serious charges, didn't even try to present evidence in support of a murder charge. Grand jury then indicts for I'm sure, the one thing that the prosecutors asked for. And then the prosecutor goes out and tries to wipe his hands of this decision, saying, oh, well, the grand jury didn't indict. It's a lot of CYA at that point. But that is rare. And you really only see this kind of use of the grand jury, which is a use of a grand jury to investigate but not really indict, is generally only when it's, a law enforcement officer who's under investigation. But this general idea that prosecutors can sort of use the grand jury in political ways, right?
Now, you're probably dealing with, business cases that are being prosecuted by career prosecutors who are not political appointees, and are somewhat insulated from politics.
They're not up for election.
Right.
Yeah.
But certainly, particularly in state prosecutions, you often have elected DAs, elected prosecutors, elected AGs that are pursuing these cases. And going back to the Trump indictment, certainly there, our former president, what is his name? Donald Trump. I think he issued like a press release or whatever this thing is that he does now.
I don't even know what he
where
does
he
now.
sort of like sends out these missives to his followers. But, he has certainly tried to spin the indictment as a political act.
Sure.
So he would be in favor of the news stories that portray what occurred as the act of the prosecutor and kind of looking past the grand jury and saying that these are just political actors in the New York political system and they're out to get me and it's a witch hunt. Presumably on the other side of that, the New York AG and the Manhattan DA would say, oh, no, we presented the evidence to the grand jury. We just followed
the evidence. That's what they say. We just folled the evidence.
We presented the evidence to the grand jury, and the grand jury decided to indict.
Right. I do think that's. I don't think it's just very true for a prosecutor to try to pass it off like that, because given how much control they have. But the two things are not mutually exclusive, right? The fact that it's political is likely true in some sense. The higher profile you are, the more attention you get, and he is the highest profile right now, right? But the system can still be unfair. It pains me to ever agree with, our former president on anything, but, it is fundamentally an unfair system. It doesn't mean it was unfair against him. I've read enough news stories about it. Yeah. What's in the indictment, but, and a high profile case like that, the prosecutors are going to have a very locked down case. Right. They don't want to get embarrassed and lose later.
But so in both of those cases, the Trump case and the Breonna Taylor case, it's weird linking these two because they seem so different and they're about such different conduct. But in both of those cases, you could make the argument that the grand juries in both of those cases are sort of being used as political cover. Now, I don't want to cast aspersions on what's going on in New York. Maybe there's no political element to it at all. But I think there probably is. I
think it's probably political tools rather than cover. Yeah, I mean, it's they can be used for both. You can genuinely go after someone for committing a crime that also helps your career as a prosecutor.
Yes, exactly. And I think it's probably fair to say that the type of conduct that is charged in the Trump indictment has occurred in other places where it has not been indicted.
I think that's probably right. Yeah. I think that's probably right. I also think it's just about where they're able to train their focus, and they're going to train their focus on you. You're probably
and so that initial impulse probably had some political element to it. I don't think it's talking out of school to think that. Yeah. But in both of those cases, so in both the Trump case and the Taylor case, the grand jury is being used as a little bit of cover for something that is politically motivated. And, would it be better in cases like that to just not have a grand jury and just say, look, if you're the prosecutor and you want to charge somebody with a crime, just charge them with a crime and let's have a trial. And then at least it's clear to the public, right? Because what makes these cases important is that the public is watching, right? Right. And the public is sort of judging the criminal justice system through the lens of these relatively small number of cases that come into the public view, right? So I think in both the Trump case and the Breonna Taylor case, one is being criticized from the right, one is being criticized from the left, but the criticism in both cases is the charging decision was political and therefore not necessarily legitimate or not necessarily serving the ends of justice, right?
I agree, except the difference I would see, and granted, is this, do I come from a certain bias and a certain perspective, is I haven't seen any criticisms of what was presented to the Trump grand jury.
Right. No, I'm just saying that is the criticism that's being made from the right. Right. That this is a political prosecution. Right. Right.
Except, agreed. And the impetus of both may be political in 50%, 75%, 25%, doesn't really matter. To me, the important thing is, and that's going to happen. If folks don't think that prosecutions are brought for political reasons, I mean, you're insane. I mean, they're brought for political reasons, not necessarily left versus right, Democrat versus Republican, but prosecutors who want to, look a certain way or look tough on crime.
Right.
But once you get to the grand jury, you should have to present real evidence, and you should present evidence of the crimes that you think were committed. And so if you're looking at cops and saying we're not going to seek charges where arguably we would if this was not a cop, that's deeply problematic.
So could you imagine a system where where grand jury secrecy, because part of the problem is the secrecy, right? In other words, if grand juries were public events, then this kind of like prosecutorial manipulation of the process would be harder. Like if people could watch the grand jury in process. Yeah. So like, could you, I'm just throwing this out there as an idea, could you imagine a world where grand jury secrecy, instead of being the default, that there's some standard where we say, okay, there are certain kinds of cases where it makes sense to have grand jury secrecy and other cases where it really doesn't. And we should allow more public visibility into the process as it's occurring.
The problem with that, I see as a defense lawyer, is grand jury investigations can last a long time. So for white-collar cases, they might last 2 or 3 years. You might actually have sort of 2 grand juries that are looking at it. If you allowed, any witness testimony or whatever to be public, you're running a real risk of exposing a person who is under... The government is at the beginning of their investigation, and they have to use the grand jury to begin their investigation, to take testimony, to request documents. But the government does sometimes start that investigation and then decide there's nothing there, right? So there's a lot of advocacy that goes on from my part. And I've definitely been in grand jury investigations where the investigator's starting, there technically has been a grand jury convened about that matter, and then we convince them either it didn't happen, it's not a crime, you're not going to be able to prove it at trial, whatever, and it does stop.
But that convincing is happening outside the grand jury.
It is happening physically outside of it.
You're having meetings with the prosecutor or sending them letters or whatever, trying to convince them to give up the investigation.
Exactly.
But you're not in the room.
I'm not in the room. Yeah. But if you allowed grand jury proceedings to be public, and at the beginning of an investigation they had a case agent say testify about John Smith and what he did wrong, that gets out into the public. John Smith, his reputation is then trashed.
Well, how about, okay,
right?
so...
And then they may never indict him. They might decide, not that the grand jury doesn't decide to indict him, I mean the prosecutor decides to drop the case.
Okay, so my idea was a bad idea.
Yeah.
So how about, okay.
I was trying to be nice about that, but yes.
Yeah. So let me try a different idea. How about, and thinking about the Breonna Taylor case, the result there, how about in cases where the grand jury investigation results in an indictment, that at that point, the grand jury proceedings are public, sort of unsealed. So again, so that there would be, because I'm, and granted, in the vast majority of cases, maybe none of this makes any difference, but I'm looking at it from this perspective of wanting a criminal justice system that gets to the correct result, and also a criminal justice system that has public support, right? And what you see through these cases, again, like the Trump case, like the Breonna Taylor cases, is that there is this critique of the criminal justice system that I think leads people on both the right and the left for different reasons to sort of conclude that the system is broken or it's fixed. Right. Well, I mean, fixed not in the bad way, like the fix is in. Yeah. Or that if you're poor or a minority, it's unfair to you. Or on the flip side, if you're really rich and a white guy, it's unfair to you. Right. Whatever you think is whoever you think is the person that it's unfair to. But what can we do to kind of make the system a little, both to make it more fair, but to also increase public confidence in the system? And it just seems to me that these grand jury secrecy rules sort of undermine public confidence in the system when you have these high profile cases. So that's interesting. I mean, I'm not sure that the grand jury is the biggest problem. I do think it's the discovery issue is the biggest problem, and the playing field after you're indicted is more often what leads to people being convicted when they shouldn't have been. Because you have to have a lower standard to charge people. I mean, you can't say, I think it'd be impossible to have a criminal justice system that works where you say to charge someone, you have to have proof beyond a reasonable doubt.
right? Or, who is the person who decides then or whatever, would be pretty much impossible. You would end up not being able to indict a lot of people who have committed very bad crimes because at the beginning you may not have all of the evidence and so forth. So it probably creates some problems to put in a really strict standard then. So you do need a lower standard to charge people. I'm just not sure the grand jury is deeply problematic for a lot of reasons. It's hard to imagine that making it more transparent will fix them. I think you can make it public as long as you have that lower standard and as long as you have it to the process where only the prosecutor is in there presenting their side, then that's where it's unfair. I mean, to me, the only systematic change you could make is let the defense lawyer sit in there.
Well, right. And
why not let me cross-examine the case agent? Why not let me and my client sitting there let me make arguments? I don't even, I don't get to make legal arguments to the jury. We do not get to present a side to it. That would be great, except that becomes a mini trial, and then the whole system just shuts down.
Right.
Right.
Well, but that is the system. That is the system in a lot of places, right? There are states like in the U.S. where at the state system they don't use grand juries. They use what do you call it? Preliminary hearings, which is essentially that, right? It's like a little mini trial.
Yep.
And I don't really know exactly like what distinguishes that from the real trial. But I take it there's maybe some quicker, constraints on what could happen at the preliminary hearing that make it go faster, at least.
They could put on a single case agent to testify
But I think in those circumstances, that is a proceeding where the defendant knows that it's happening and has the opportunity to participate and cross-examine and so forth. So it's sort of close to sort of what you're suggesting would be a more fair process inside the grand jury, right?
Yeah, agreed. There's so many strategic problems in that at the beginning of the case, I don't know very much. I haven't even gotten discovery from the government, right? So from this whole process from the very beginning, I don't have the information. The government doesn't have to give me anything. So my client can be in a 3-year grand jury investigation and I have received nothing from the government. They don't have to show me anything or tell me anything. And so I'm not even adequately prepared to challenge it at that stage. So to my point, until you get the discovery rules fair, it's stacked.
So that's what you want. So the Sara Kropf wish list is just sort of give me sort of the equivalent of civil litigation discovery in criminal cases, which makes total sense because, I mean, you could make a very strong argument that the stakes are much higher in criminal cases than they are in civil cases. I mean, some civil cases are very big and contentious cases, but ultimately they're about money. Nobody goes to jail, right?
It's amazing.
So if you can get 6 months of very expensive discovery in a fight over $100,000 in a civil case, why can't you get that when you're being accused of a felony and you might go to jail for decades?
Yeah, and I mean, you can make the argument that there's a very limited number of cases where witnesses would be at risk, and you don't want to give up confidential informants. That's just not the kind of work I do, right? I mean, there aren't witnesses who are physically in danger from testifying in my case. So it's staggering to me, especially since I do both civil work and criminal work, to look at my civil cases and think I can issue subpoenas to banks and to whomever and, try to defend my clients. And then it gets to a criminal case and I'm stuck with what does the government want to give me? So that to me is the primary thing that is unfair. I mean, putting aside all the racial injustice and, the economic problem of if you can't hire, a huge law firm or even a small law firm to represent you, the inequality. So you take the inequalities I'm talking about and just make them bigger and bigger if you're a person of color or a person without means. So
I guess just to kind of maybe wrap up this topic, and we'll talk about some more fun things.
On a high note or something.
Yeah. This is depressing. I don't know what the high note is on this topic. It sounds to me like there are some, again, we're just focusing on the grand jury, but you're saying that there's bigger systemic problems, which I'm sure there are. But even just focusing on the grand jury, there are some real serious questions about whether that process is necessary, whether it's fair, whether the public understands it adequately. So there's a lot of room for reform there.
Yes.
And it'll be interesting to see if that ever happens. I mean, again, we're kind of stuck a little bit. I mean, and we haven't pointed this out, but in the federal system, there is actually a constitutional provision that at least for some limited number of cases, I'm not really sure what the scope of that is.
Yeah.
But the grand jury was was seen back in the 1700s as a important civil protector of civil liberties.
Right.
And it may not really be functioning that way anymore.
I think that's probably true. I guess the thing that we don't know, and I try not to be too negative about prosecutors, it is at least they have to stand up in front of, 16 to 23 people and present their case. And it does probably stop the most absurd cases from being indicted. So, there is a very minimal check there. And they have to, put on witnesses and gather documents, which from the defense perspective creates discovery that they maybe have to produce to me. So there are some benefits, but you would have to change the system whole scale and think about whether or not it just makes the criminal justice system grind to a halt. I mean, if you make the grand jury system more complicated, it's not necessarily a bad thing, but it would take wholesale changes. Like I don't think there's an easy fix to it. Yeah.
Well, I guess just to wrap up this topic, what I would say is my own personal hope is that lawyers like you who are in the system and really understand it well, that there's some outlet for some healthy discussion about systemic reform, and that the people that are participating in that system actually have those discussions. And you could say the same thing on the civil side, which is where I operate.
Sure.
I could talk for hours about the problems. The civil discovery system that you want in criminal cases has a lot of problems to it. And it's enormously complicated and expensive, and it doesn't always work the way it should. And it costs millions of dollars to get trial. That's a whole other topic.
But I do think if I could put a pitch out there, is if people get a summons for a grand jury, to show up, to not try to, if it's possible with your job and so forth, to sit on a grand jury, and to know that you have every right to ask questions and ask questions of witnesses and press the prosecutors, and you have the ability to do that. And you don't see it happen, and I'm sure there's groupthink, like you're sort of all in a room and no one else is asking questions. Are you going to be the one guy asking questions?
Well, that's interesting.
But, you're allowed to do that. It's the same way there were efforts in the past to educate jurors about jury nullification, right? And that's seen as very controversial. Well, you have the absolute right to as a juror to say, I'm not finding that person guilty. You don't have to explain it.
Yeah,
and
that is interesting.
Yeah.
And so your point is, I think what you're saying there is that maybe the solution isn't to get rid of grand juries; it's to sort of empower the grand jurors a little more.
Yeah.
And certainly that handbook that I read from the Handbook for Federal Grand Jurors has that tone to it.
Does it say they can ask questions?
Yeah.
I mean, I'm going to have to write a blog post.
Yeah, I'll give you this.
Yeah. Keep an eye out for my upcoming
You can have
post.
This when you walk out of here today, although you can find it online. But certainly the tone of it is that they're telling grand jurors that you play this important role in the system, and you have this power, and you're a check on governmental overreach and the Magna Carta and all that stuff. And maybe the reality is that once they get into that room and the door locks and the only person that they're hearing from is the prosecutor, that it's hard for them to actually play that role that they've been told that they should play.
Especially people from groups who have been marginalized. I mean, imagine being the only black person in the room.
Sure. And
everyone else is like a retired, white person.
Yeah.
The idea that you're going to speak up is, it takes an incredible act of bravery. Yeah. And, I see people on jury trials in criminal cases trying to get out of jury duty. And some of them even express, they've been on other juries and they felt like they were marginalized and made to feel uncomfortable because they were pushing back on convicting. And, people need to serve on juries. And we need a broad spectrum of people to be on and on grand juries.
But it sort of suggests that maybe some sort of milder, easier to implement kind of reforms could just be around the way that the grand jurors are treated, how things are explained to them about their role, even just kind of the way the rooms are set up. I mean, there's all kinds of social psychology type of learning that you could bring to bear to say, okay, if we really want the grand jurors to play this role that we tell them they are playing, we have to make them feel like they actually have some power and not do things that make them think that they don't.
And maybe it's telling that doesn't exist.
Yeah.
Because the prosecutors have complete
Prosecutors don't want it.
Right. But it's much easier for everyone just to be nice and quiet and return indictments.
Right.
So,
but hopefully there are other people in the system like the judges and the defense attorneys and, that might want that type of thing.
Yes.
Okay.
Well, wasn't that fun?
Yeah. So let's stop talking about grand juries.
All right.
So I wanted to just kind of ask you about a couple of other things that you've written, because you're an avid blogger, and I read things that you write on your blog and that you post on LinkedIn. Do you Twitter also?
I do. I tweet.
Okay.
Yeah.
All right. Yeah. So I'm not a huge Twitter user yet. So I
Stay away from it.
I see your stuff on LinkedIn.
Yep.
And so you've written some things about the dynamics of big firm practice versus little firm practice.
Yep.
And I think you're almost sort of like uniquely qualified to talk about some of this stuff, because you obviously spent quite a long time at a big firm, as both an associate and as a partner. So kind of like, you moved up the ladder and you held the different sort of positions of power and authority within that structure. So you have a good sense of what it's like to be at those different positions, right? And then now at a small firm. So let me start with this. You wrote a piece on your blog a while ago that was just titled "What It Takes to Be a Trial Lawyer If You're a Woman."
Oh gosh, I don't remember it's what.
Okay, you were.
Read it if you want me to.
I'll just tell you. You wrote this piece and you were responding to something that some other female attorney had written, where she was talking about the difficulties of being a female trial lawyer, because she felt that she's being sort of perceived differently than male trial lawyers and is being judged differently. Yep. And you wrote a piece sort of responding to that, sort of saying, well, maybe yes, maybe no. You know, that if you don't worry about those things and you're just sort of be yourself, that like maybe it's not as big a problem as you think it is. I think you were trying to write like a more hopeful, positive piece for female lawyers to say, like, don't go into the courtroom thinking that you're going to lose. Like, you have to go in thinking you're going to win. And if you're worried that people are looking at your hairstyle, and if you're convinced that that's what's happening in the courtroom, you're just not going to do well, right? Right. But one of the things that you said in that blog was that you said, and I'll just quote, you said, "One place you can find amazing lead trial lawyers who also happen to be women is in smaller firms." That's what you said. Yeah. And looking around at the lawyers I know, that does tend to be true. Yeah. So why do you think that is? Like, why do you think it is that women attorneys, good women attorneys, end up at small firms as opposed to big firms? Or maybe I should start by saying, like, do you think that that's true?
I mean, I know tons of amazing women who are still at big firms, but we all know the numbers that women leave big firms in higher numbers. There's probably a million reasons for it. Family, who has obligations at home and so forth. When it comes to trial lawyering, I know in my career, all the people I went to trial with were all men. All the lead lawyers were. And that's not to say they weren't great trial lawyers. I mean, I worked with one partner who's probably the best trial lawyer I've ever seen. But it is really hard in a big firm, as a woman, to be a lead trial lawyer. And in part, that's just the business of it. And it's that in order for a client to have you as the lead lawyer, it generally means you're the relationship partner with the client, because the client trusts you the most. So if it's not your client, then it's hard to say, well, I'm going to be the lead lawyer. As you get more senior and you're bringing in your clients, then they want you. They picked you, right? They hired you. If I was on a case at my old firm, at a big firm, usually always someone else had brought in the case. And so I was lead counsel on one civil case, and that's because the partner, who was the relationship partner, said to the client, look, Sarah knows the case, and she's going to do a better job of it. The client listened to that advice, which is another hard part of it. Right. And I was lead lawyer, but the other lawyer, I mean, he was there. Like, he was second chair. That is rare. I can tell you that experience doesn't happen to most women. And so I think you see a lot of women who want to be trial lawyers starting their own firm, because then all the clients are mine. Right? I am the trial lawyer because they've hired me.
But why couldn't you just be that person at a big firm?
It was just going to take too long. Right? I think you can. I certainly don't think it's impossible at all. And I do think it's changing as you see more women being in-house and making selections. I do think that's going to change. But you have to be the rare woman who not only goes to a big firm in the first place, stays at a big firm, watching a lot of your friends who are women leaving, face all kind of the little barriers that happen along the way, and then also become a trial lawyer, which at a big firm is incredibly difficult. There's just not that many. I mean, from the civil side as well. Cases just don't go to trial.
Yeah.
So it's a small number, and you got to fight your way into those cases.
Right.
So if you think about, it's hard to become a trial lawyer at a big firm, period. And it's even harder, a little bit harder for a woman if the clients are not yours.
Right.
So, but they do exist. And I don't think being a great trial lawyer has anything to do with being a man or a woman. I mean, I just don't, I genuinely do not believe that going into a courtroom that it hurts me to be a woman. I think in many ways it helps me. So, but it does take a certain level of confidence.
What are the ways that it helps you?
I get to, you've been in court, right? It's a very physical environment. I can stand a little closer to people, right? I can get closer to the jury than a 6'4" guy. I can stand a little closer to the jury. Mm-hmm. I can make eye contact with people in a way that is maybe a little less uncomfortable. Mm-hmm. When I have a criminal client, and they've pretty much all been men, I can put my hand on their arm, put my hand on their back. I don't think that's viewed as weird, and I think it helps humanize my client. Mm-hmm. So I don't think it hurts me. There is a fine line. I think women are more quickly judged as aggressive. And questions and a questioning style that no one would think twice about a man doing. Mm-hmm. I think you have to be a little, if you have that kind of personality, you have to scale that back a little bit in the courtroom as a woman, which I think is unfortunate, but it's not my personality, so that hasn't affected me. But I mean, 2/3 of being a trial lawyer is just the confidence to go in there and do it.
Yeah.
Right. And it takes that confidence, but part of that confidence comes from seeing other people like you doing it.
Yeah.
And so it becomes a little bit of a vicious cycle. So I think you do see people who want to be trial lawyers going to small firms.
Right. Yeah. No, that's
men and women.
That's
fair,
right? Definitely true.
Yeah.
So let me ask you about something else that you wrote recently, mm-hmm. That I read on LinkedIn. You probably posted it on Twitter too, mm-hmm. for all I know, but that I found really interesting. So you were talking about the fact that first-year starting salaries for associates at the larger law firms in the country are now up over $200,000.
Yeah.
I mean, it was somewhat surprising to me that it's taken this long to break that barrier, but that is a large number, and it's significantly higher than it was when you and I started.
Yep.
And it does seem like a lot of money, and it raises some just interesting questions about the economics of law firm practice, and in particular for young lawyers, or maybe young isn't the right word, for new lawyers, mm-hmm. right? Because some people go into it as a second career, so they might not be young, but for new lawyers, mm-hmm. people that are recently out of law school and are being faced with choices about career paths, what jobs to pursue at the beginning of their career, that there is this sort of, what I think of as a giant sucking sound that comes out of the big law firms. And this was true 30 years ago as well.
Yep.
But maybe the disparity has become more stark. This giant sucking sound that comes out of the big law firms because they offer such high starting salaries. Yep. And those salaries go up very rapidly also, yep. and people understand that. So there's a lot of money to be made for a young lawyer to go into one of these big firms if they're lucky enough to be offered one of those jobs. Not everybody gets offered those jobs, but for the ones who do get offered those jobs, and in some sense, the target of those big law firms tends to be people that are graduating from top 25 law schools or have done really well in law school. So they're sort of trying to skim off what they perceive to be the creme de la creme, whether that's mm-hmm. true or not.
It's another podcast.
I have my doubts about whether that's true, but they're using the metrics available to them.
Sure.
Let's say. And they're trying to skim those people off, and they do it by offering very, very high salaries. And that, raises some questions about the sort of the choices that those newer lawyers are faced with. Should they take the money and go work for the big law firm,
right?
Or should they pursue some other path? And you wrote in your post that your initial reaction to sort of the criticism of people being criticized for taking those jobs was sort of to sort of defend the big firms and to say, well, big firms don't only do evil things.
Right.
They do some good things, right. and their clients deserve to be defended as well.
Yep.
And not all of the plaintiffs' lawyers are such angels either. That there's bad people in the plaintiffs' part too, which I will stipulate to. So so that was your initial reaction, but then you apparently had read some other stuff, sort of talking about some other choices, and here's what you wrote. You're talking here about some other responses to that you had read online. You said, quote, "These lawyers had a much better response. They pointed out the unfairness of criticizing lawyers for taking high-paying big law jobs for a much simpler reason: the money. Many lawyers come from less privileged or wealthy backgrounds. Everyone deserves a chance to rise up, to help their families, to pay off school debt quickly. Why fault them for taking a $200,000 salary to do that?" Which I thought was interesting. So, and again, you come from a sort of unique perspective of having been at one of those big firms and now also seeing other paths that people could take.
Right.
I guess if you were to give, let's say somebody came to you who is a third-year law student or a recent law school grad, and they asked you, well, should I take this job I've been offered by big giant law firm where they're going to pay me $200,000, or should I look for something else to do? Like, what would you tell that person?
I mean, I think part of it does depend on how much debt you have. Look, I did not grow up poor, and I certainly did not grow up wealthy, and I had a fair amount of debt, and that was a huge reason I went to a big firm. So I don't see anything wrong with that at all. And I learned an unbelievable amount at the firm, and I'm really glad I did it. So, and I have had people ask me that question, and it's, what kind of debt do you have? Do you want to pay it down quickly? Because you don't have to pay it down quickly, but it's nice to. I don't think you can really go wrong going to a big firm for a couple of years. I mean, it is going to help your resume. You're going to learn something. You're going to learn you love it. You're going to maybe learn you hate it. You're going to be with smart lawyers doing complex work. Maybe you aren't doing the most rewarding part of that work, but you're hopefully going to have a long legal career, and there's plenty of time to go do something else. So I don't have any problem recommending a big firm if someone is thinking about that. Okay,
so that is the conventional advice, what you just gave.
Yep.
So let me just offer a potential critique to that.
Go for it. Yep.
Which is that, and this was my experience.
Yep.
Okay, to be honest.
Yep.
Which is that I took that big firm job for exactly the reasons you just said.
Yep.
Had some debt to pay off, good resume builder.
Yep.
I figured I would go in for 24 months and be out.
Right. So did I.
It took me 7 years.
Yeah, it took me 11.
Yeah.
So,
And the reason for that, I think, is that large law firms are sort of what sociologists call total institutions. That when you are inside of them, it is very difficult to see the outside.
Yes.
And that's because they and maybe this is going to become less true over time, and this is, but at least when I was there, they expected you to sort of be on call 100% of the time.
Yes.
And they expected the job to take precedence over almost everything else.
Yes.
Almost everything else.
Yep.
Or maybe everything else.
Yeah. I'd say almost, but yes.
Yeah.
For most normal people, it would feel like everything.
Yeah.
Yeah.
And so what happened for many people, I think, is that they got inside of this institution, the big law firm, and they start to lose touch with their friends and family that are outside of it because they don't have time to keep up with other relationships.
Yep.
And within the institution, they're being told that the best thing you can ever be as a lawyer is a partner at a big law firm. That is the pinnacle of success and so forth. And when you're inside of that institution, it's very hard to kind of see back outside. And so regardless of what intent you had the day you accepted the job offer, 2 or 3 years later, you no longer even remember that. Like, I think maybe that's an exaggeration, but I think for a lot of people, they get sucked in to that institution. They lose sight of kind of maybe what their motivations were for going to law school in the first place. And hey, the money's great. and I have a nice car, and I have a big house with a big mortgage that I have to now service every month. And why not just stay? Why not just stay one more year? Yeah. And so there is this natural process where I think that people who might otherwise, very smart, highly educated, motivated people who might put their skill set to use in other ways just sort of end up stuck inside of big law firms, at least for some period of time. I mean, most people do eventually leave. Yeah. But, and like, is that good? Is that good from like a societal perspective?
Probably not, but I mean, to your last point, most people do leave. Yeah. And I do think there's a lot of dynamics at stake. You're absolutely right that when you're in the law firm, and I felt this, you should become a partner. I'll never forget, there was a partner I won't say his name, but he gave me very good advice, who was at the firm where we were, who was a senior white-collar partner. I remember him saying to me very distinctly one time, he said, practicing law is not about just achieving thing after thing. It's about, so don't just look at it as like you want to achieve X and Y. Like, think about what you actually want to do. That only took me about 14 years to actually implement. Yeah. But I think you're right that I think they do create this environment, and oftentimes a very negative environment, where somehow big law firms take the best and the brightest in some ways and make them doubt themselves, make them doubt that they're doing a good job, because it's always about, if you build this many hours last year, you should build this many hours the next year, and create this very odd environment. So I do think now, though, even with something as simple as Above the Law, right? Even with that blog, I think people see small firms more. If you're active at all on Twitter, and there's law Twitter and appellate Twitter, you see small firm lawyers being incredibly successful doing what they do. And so I do think people have more information than they did, when we started, not to sound like curmudgeonly old people. I also think that, the golden handcuffs are very, very real. I know a lot of unhappy, and I'm sure you do too, unhappy law firm partners because they bought the big house, because they have 3 kids in private school. We had very good financial advice at the beginning, which was, we're going to live our lives as though we have 2 government salaries. And that gave me the freedom to leave my firm. And I know a lot of people who aren't in that situation. So I agree. I think law firms are fascinating. I still don't think they're a bad place to go. I do think you have to get yourself a little bit out of what you talk about. You have to be conscious about. And I will say there was probably a very long period of time where I was like, this is great. Everyone at the firm's telling me I'm doing a good job. I'm just plodding right along. I'm getting good work. And then I kind of became partner, and then stepped back and thought, here, I'm looking at what the most successful people at this law firm, what their lives are like, and not necessarily work-life balance, although that's some of it, but who they are, what they do every day, and so forth. And I was like, I don't want that.
Yeah, I don't know what your experience is,
I don't want
that moment when you finally make the decision to walk away.
My problem was that I made it too soon. I made it like in April of the year before. And then I had to sort of wait it out.
Yeah, those last 6 months of torture. I went through that too.
Yeah, I mean, it's just brutal. I was waiting for my comp to come in, and I was like halfway out the door and plotting.
You're mentally, it's an awful environment when you're not committed to it. Yeah, but I agree.
I think it's fascinating. But I'm after reading sort of these comments on Twitter, expressing a perspective I hadn't thought of. Yeah. That was in response to, there's a huge divide on Twitter, people who are public interest lawyers, and they think you must be evil, terrible, awful to go to a big firm. And I think that's a really false narrative. And then there was like the big firm lawyers who were saying, we're not all bad. Right. And that was kind of in response to, people have reasons for going that have nothing to do with,
and look,
evil.
This is, there's a bigger question here about kind of what does it mean to be a lawyer, and how identified should we be with our clients and our causes? I mean, you're a criminal defense lawyer, I'm sure all of your clients are innocent. But let's just assume a world where maybe a few of them weren't. Yeah. Right. And lawyers still have a role there, right? Like, I mean, I'm sure what you would say is that even somebody who's guilty still has a right to a defense. Yep. And we have to keep the prosecutors honest. Yep. And this person still has a right to try to get the best outcome for them that they can, even if they are going to go to jail for some period of time, or whatever the answer is. And all of those things are true. There are times when I've seen, I won't name names, but I see lawyers that I know that stayed at big firms, and they will do they will work on some case, and they will win the case.
Mm-hmm.
And then there's like some moment on LinkedIn or Twitter or somewhere where they are crowing about the fact that they won this case.
Mm-hmm.
And then you go and you look at what the case was. And I have these moments where I'm like, that's the
what you're
thing.
proud of?
Like you got this company off of, for whatever, or whatever the thing is. And look, and again, I'm not saying that the plaintiff's side is immune to that. I see plenty of greed and incompetence on the plaintiff's side as well. But I do have those moments where I'm like, I almost like feel a little bad for that person, because I'm sure like if their 3L law school self was looking ahead, that was not the thing they were shooting for. They weren't shooting for the moment in their career where they were going to get to brag about the fact that they won a motion to dismiss against some employee or some consumer that was suing their corporate client.
Agreed.
So I don't know. There's a lot of moral ambiguity in what all of us do as lawyers, and that's part of what makes lawyering kind of interesting.
Well, and that's one reason I like the criminal defense side. Yeah. On the civil side, you do, it's all about money and so forth. On the criminal defense side, it's so clear why we're important and why our role is so important that it's almost like I don't have, as a criminal defense lawyer, you don't have that ambiguity. My job is to make sure my client is getting a fair trial and the government proves its case. My job isn't to figure out if my client guilty or innocent or make sure the right outcome happens.
Well, that's interesting.
Because I would be highly unethical if I thought, well, you know what? I think my client's actually guilty, so I'm going to tank his defense. So being a criminal defense lawyer actually, to me, is a much clearer definition of roles and not feeling bad. I never feel bad about my defense roles. I mean, and it can be difficult. I mean, the Bill Cosby thing came out recently, and it's tough being a defense lawyer thinking, that was the right outcome. That was, I mean, it's a despicable things that he has already admitted he did, but legally, that was absolutely the right outcome. That's a hard thing as you put together a feminist and a liberal and a defense lawyer. Yeah. Sometimes these things conflict, but that's again another. No. But this podcast.
I think this is interesting, and I hope it's interesting for other people to listen to lawyers talk about this, because again, it's these are the things that lawyers maybe think about in their heads, but they don't often talk about them out loud.
I agree. I think I can't wait to listen to your other episodes. Yeah. See who else you get to
but it's interesting that you say criminal defense lawyers sort of have the clearest, least ambiguous, because I think most people would think the opposite. Would say, well, wait a second, you're defending criminals. Isn't that the most morally ambiguous thing you could do?
If any criminal defense lawyer stands up and they describe their job as defending criminals, then they shouldn't be a criminal defense lawyer, right? And it's until you're the person sitting in the seat as the defendant. Yeah. All of a sudden then you want your criminal defense lawyer, no matter how much the evidence is stacked against you, to be like a, true believer and doing everything possible to help you. Right. And I think it's the least, I mean, I haven't done, except for some court appointed work, murder cases. I think it would be difficult if you got someone off in a murder trial and they went and murdered someone else. I can't imagine you wouldn't feel something because of that. But your job is to make sure the government has to prove their case and your client gets a fair trial, and everything possible you can do. To me, there's no ambiguity on that side. Whereas civil cases, I still defend my clients to the nth degree, but those feels less. There's definitely, I think, more ambiguity.
Yeah. So being a criminal defense lawyer might be the height of moral ambiguity, although you say it's not. But the one thing that is not morally ambiguous is that the Washington Nationals are the baseball team we should all root for. Is that true?
That's 100% true.
Okay, so I know you're a huge baseball fan. Yep. Tell me where that comes from.
That's a good question. I was the only girl on my Little League team, and then they forced me into softball, which is not as much fun as baseball. Now they have girls who play baseball, so I'm a huge fan.
One of my daughters kind of went through that.
Nice, yeah. So I wish I could have stuck with baseball. So I always liked it, although we weren't huge fans, and it was too expensive for my family to go. But then we moved. Then the Nationals came to DC. I confess we were not the original fan base. Mm-hmm. When 2012, when they went on that run, and then of the game we shall not speak at the end of those playoffs. But we became fans, and I have two boys who both play baseball, or did, one now Rose, but we're big baseball players, and so we've just become, so we are season ticket holders, and are huge fans.
Yeah. And so you follow it closely and have strongly held opinions about it.
I do.
You do. So again, we're in July of 2021.
Yep.
As of yesterday, at least, the Nationals have a losing record, but are only 4 games out of first place.
Yes.
Because they're in a division full of losing teams somehow, remarkably.
Yes.
So here's the question. Are the Nationals going to make the playoffs this year?
Absolutely.
Well, okay. So how is that possible?
I say that with incredible certainty.
So just to review the bidding, right? Yeah. They made a remarkable surge all through June.
Yep.
Mostly because one player, a guy named Kyle Schwarber,
yep, went
on one of the most remarkable tears that any major league player has ever had.
Yes.
This is a guy who's been in the league for many, many years.
Yep.
He's has a long track record, and suddenly in 1 month he outperforms his own. He was a good player.
He was a good
all
player.
Those years, but he suddenly becomes Babe Ruth.
Yes.
For like 1 month, and basically carries the team.
Yep.
And then at the end of the month, he runs out a single, turns first base, and pulls his hamstring.
Yep.
So he's now out probably for a while. So so what are the things that you think have to happen for the rest of the season for the Nationals to have a shot here?
I mean, we need Saras to come back. So we need Steven Strasburg to come back and actually stay healthy. I mean, that's obviously been the knock on him. If we're going to give up Anthony Rendon to keep Saras needs to step it up and not be injured.
Yeah.
So if he comes back,
although we don't blame the victims. I mean, like,
we don't.
He has a history of injuries.
Yes.
And maybe has gotten a little bit of a bad rap for that.
Yeah. I mean, I love him. So so we need that. We need Patrick Corbin to have control of his fastball so that his slider is just crushing batters. We saw that last night.
Yep.
We need Soto to keep doing Soto things, which is just hit after hit after hit. And Trey Turner to keep doing what Trey Turner does.
Yeah.
So I think those are the keys. And then what I love about this team is it feels a little bit, and like I'm going to knock on wood and cross fingers and all that, like 2019. You have these little spark plugs. Yeah. You have like Josh Harrison coming in, who just seems like he's having fun.
Yeah, he's great. He's great to watch.
Yeah, he's just a blast. You're watching, I forget what his first name is, Espino, the pitcher.
Oh, yeah.
Who comes out of
Paolo.
Yeah.
Yeah, this guy's never been in the majors until he's like in his 30s.
He's killing it.
He throws at 70 miles an hour.
Yeah.
His fastball's like 75.
Yeah. And what's his ERA?
Yeah, it's like 2 points something.
Yeah, exactly. Yeah. So, I feel like you need a couple of these little magic things that shouldn't, you don't expect to happen, because I feel like that's what happened in 2019. So I think it's still tough. I'm a firm believer that the Mets always collapse, and they will collapse again.
History is on your side.
History is on our side, right? So I'm a view of, we just need to probably stay ahead of the Braves, is my view. The Mets will do what the Mets will do. You can't control that. They're gonna fall apart. Knock on wood.
Well, I think the baseball is a unique sport in the sense that it is so long. Mm-hmm. The season is so long, and they play so many games.
Yep.
And even though it's not a contact sport, it doesn't look like it's a sport where people should get hurt.
Right.
And yet there's a lot of injuries in baseball.
Yeah.
Because I think it's because baseball players, unlike, say, a football lineman, what they're doing is so finely tuned that the types of injuries that like somebody might just fight through in football or basketball or maybe even hockey, in baseball it just disables them.
Yeah, I agree.
Like
and
if
the pitchers,
if they have a problem in their arm, they just can't control the ball.
They tweak a neck, or they tweak a leg. Except Max Scherzer, who can just play with a broken nose. But I think a lot of magic has to happen. But I just love the Nationals. I'm a huge Davey fan now, and who puts Kyle Schwarber as your leadoff hitter? What's that guy weigh? About 230? I mean, he's not a leadoff hitter.
I would love to sit Davey Martinez down and ask him why he did that.
It was brilliant.
Was it? Is that like an analytics thing? Did they figure out something, or was it just a hunch? that
I feel
worked
like
out.
it was a hunch, right? That happened to work out, and it could have.
It happened to work out because just at the moment they gave him the leadoff spot, he went on this crazy tear.
Yeah.
Like if he had just been normal Kyle Schwarber, it wouldn't have seemed like such a great move, right?
But I was a believer from the beginning when his batting average was so bad, and Josh Bell.
Yeah, that they would revert.
They were gonna, and when Soto came back from being injured, that they're we're doing it. It's like they're not gonna stay cold for the whole season.
Yeah.
There's zero chance. So.
Yeah. Well, I'm with you. I think they have the talent still. And if they can all get healthy at the same time, that's the key.
Yep.
They need some of their bullpen back too. Their bullpen's depleted right now. But if they can get, Daniel Hudson's on the IL.
He's back.
Oh, is he back now?
Yeah.
Okay,
Hudson
that's good
just
news.
came back.
Okay.
Yes.
So you're ahead of me on this. All right. So that's huge.
Just yesterday.
That's huge.
Yeah.
But I don't think we've really heard what Schwarber's prognosis is yet.
They didn't put him on the 60-day IL, so they put him on the 10-day, I think. But I think it's hard to imagine he's coming back after 10 days.
Yeah.
So,
but if they can kind of stay within shooting distance until he's back, and if Soto can stay healthy, if Trey can stay healthy, if the two Joshes can stay healthy, then they've got and Zimmerman.
And don't even get me. We need another hour to talk about Zimmerman.
Yeah.
I do think they have the toughest schedule before the All-Star break.
Yeah.
If they can just hang on and stay within like 5 games, their schedule after the All-Star break is very easy.
You did the same thing I did,
right?
So
I'm like, just stay close.
The last month of the season, we play a bunch of not so good teams.
I know. Did we knock on wood enough in this one?
All right. Well, that seems like a fair place to end it. Go Nats.
Yes. Go Nats.
And thank you, Sara Kropf, for being my inaugural guest on the podcast.
Thanks for having me. This was great.
Okay. Thank you.